The profile of the court changes a lot starting in the 1950s. It's not that the court hasn't been involved in rights protection before that, but when it decides Brown versus Board of Education in 1954, it really begins a new era. In part, that's because there's a new Chief Justice, so we like to talk about courts in terms of the Chief Justice, so that always the Warren Court era. But it's not just that, it's also what they do in Brown versus Board of Education. And Warren was actually a politician. He was the governor of California, and he thinks about what the court's image looks like, and he thinks about how the world is going to respond to Brown. And in fact, he writes Brown, and he makes sure it's unanimous, and he writes a short opinion because he wants the major newspapers to carry the whole opinion on their front page, and they do. And that is one of his goals, is to show the court is doing this, and people need to see what it is the court is saying. But what happens when the court decides Brown is that it enters into politics in a big way. And in fact, it knows that it's entering into politics in a big way. When it decides Brown, it answers the question of whether the 14th Amendment prohibits segregation, racial segregation in the schools by states as an official legal matter. And it says that the 14th Amendment does prohibit school segregation. But what it doesn't do in Brown is answer the question of what schools are supposed to do about that, because it's really worried about what's going to happen. So they hold argument again, and a year later, they decide what's called Brown versus Board of Education 2, which is just about the question of remedies. What now do school districts and schools and states have to do to fix this problem? And this is another time when a lot of people think that the court blinked, because they use a phrase that comes to be the touchstone. They use the phrase that schools have to be desegregated with all deliberate speed. What's deliberate speed? I don't know what deliberate speed is. You would think deliberate and speed are opposites, right? That's an oxymoron, and yet that's what they say. And the white Southerners who are committed to maintaining segregated schools, even after Brown, take this as a signal that they don't really have to do a whole lot. The NAACP, which was litigating these cases, had asked for September, right? They said by the time the next school year starts, schools should be desegregated. That's not what the Supreme Court decides. The Supreme Court decides with all deliberate speed. Now, I do think that there is a different way of thinking about Brown, actually, which is much broader than that and gives the court a lot more credit. And that is that the reason the court doesn't think it makes any sense to say September is because the court is thinking that what's required for desegregation is new boundary lines between schools, new bus routes, moving teachers around, moving students around. What the court imagines is real integration, is real desegregation. If the court had thought, all you have to do is pass a new law saying we won't segregate our schools anymore and the schools can remain the way they are, in fact, you could do that by the September, right? That wouldn't be a problem. So I actually think the court had a really ambitious view of what desegregation was going to mean, and as a result, they thought it was going to take a while. But they do leave this opening of all deliberate speed. And what happens after that in the South is what's often called massive resistance. There's a Southern manifesto signed by almost every member, Southern member of Congress, of the House of Representatives and the Senate, that says we will not abide by this. The court doesn't have the power to do this. The court is acting politically, not legally. The court just can't decree that something is unconstitutional that we've been doing for 50 years. And it's illegitimate, it's political, it's biased, and we won't follow it, right? So this is the kind of language you saw during the Civil War, right? We're replaying the kinds of debates about who has the power, the federal government or the state governments, who has the power, the court or the elected officials, right? All of these themes are being replayed in the civil rights era.
There's still a large number of segregated school districts throughout the country when Brown comes down. So Brown works a significant change across the entire country in many ways. At least a significant change in theory. In fact, what we know is that not a whole lot changes for a long time after Brown, that there is massive resistance in the South. Even in the North, there isn't significant movement towards desegregation in many communities. It takes there's a subsequent ruling by the Supreme Court, Brown 2, where the court says you have to use all deliberate speed. That doesn't really get anywhere. There's then you have Orville Faubus in Arkansas standing in the schoolhouse doors. You get Cooper versus Aaron in 1958, where the Supreme Court says, no, we mean it, you have to desegregate now. Still doesn't really do much. So I think a lot of people regard this as an illustration that actually when the Supreme Court tries to lead on issues of social change, it gets thwarted. It doesn't actually succeed very much. In my view, by far the most important elements of the civil rights movement in the United States are the Civil Rights Act of 1964, the Voting Rights Act of 1965. These statutes passed by Congress that both of them work momentous changes in both our sort of social and our political landscape. And what the court's role there really is that it got out of the way. The court upheld the Voting Rights Act, it upheld the Civil Rights Act, and it didn't strike them down, and it allowed the federal government to enforce them throughout the 60s, 70s, 80s.
People often talk about the Warren Court as an incredibly activist court, that the Warren Court really proliferated cases in which they were protecting individual rights of various kinds, race discrimination, religion, free speech, and eventually the rights of sexual autonomy and reproduction. Although in that, the Warren Court really starts the process, and it's the Burger Court who finishes the process. So there's a 1965 case called Griswold versus Connecticut, in which Connecticut prohibited the use of contraception even by married couples. There were lots of state laws prohibiting the distribution of contraception and all kinds of other things, but Connecticut was one of only two states, Connecticut and New York, who had laws that were that stringent, right? That law goes right into the marital bedroom and says, this is what you as a married couple cannot do. You cannot use contraception, even among a married couple. And the Supreme Court says that's unconstitutional. That's not okay. Connecticut can't prohibit a married couple from doing that. And that's the first modern case that really starts to set out that you have certain rights of privacy, of autonomy, a sphere of personhood where the court is going to protect people from the state. Now, the state might have good reasons for wanting to regulate in that sphere, but there are some times when the court is going to say those reasons aren't good enough. And that leads into the abortion cases that really get taken up by the Burger Court in the early 1970s, culminating with Roe v. Wade in 1973.